Well, we now know the name of the person who is likely to be named as the so-called special master in the criminal investigation of Donald Trump, but we don't yet know what that special master will actually be doing. That is one piece of our breaking news coverage in this hour, which includes new filings in the case this evening by federal prosecutors and Donald Trump's lawyers. The other sprawling mass of breaking news that we have tonight is reporting in the New York Times by a team of reporters, including our first guest, under the headline, Justice Department issues 40 subpoenas in a week, expanding its January 6th inquiry. The Times reports Justice Department officials have seized the phones of two top advisors to former President Donald J. Trump and blanketed his aides with about 40 subpoenas in a substantial escalation of the investigation into his efforts to subvert the 2020 election. People familiar with the inquiry said on Monday. The seizure of the phones, coupled with a widening effort to obtain information from those around Mr. Trump after the 2020 election, represent some of the most aggressive steps the department has taken thus far in its criminal investigation into the actions that led to the January 6, 2021 assault on the Capitol by a pro-Trump mob. Federal agents with court-authorized search warrants took phones last week from at least two people: Boris Epshteyn, an in-house counsel who helps coordinate Mr. Trump's legal efforts, and Mike Roman, a campaign strategist who was the director of Election Day operations for the Trump campaign in 2020. People familiar with the investigation said. The Times reports that Bernard Kerik, the former New York City police commissioner appointed by Rudy Giuliani when Giuliani was mayor, has also received a subpoena. Bernard Kerik helped Rudy Giuliani promote false voter fraud claims. Bernard Kerik's lawyer confirmed to the New York Times that he was subpoenaed by the U.S. Attorney's Office in Washington, D.C. Bernard Kerik is the only person in the subpoenaed group of Trump associates who knows what life is like inside federal prison. He is the former New York City police commissioner who was convicted of federal felonies and served time in federal prison. And of course, Donald Trump is the only president of the United States who would seek out and accept help from Bernard Kerik after Kerik got out of prison. The Times reports, according to one subpoena obtained by the New York Times, they asked for any records or communications from people who organized, spoke at, or provided security for Mr. Trump's rally at the Ellipse. Also this evening, the Justice Department filed its response to Donald Trump's list of suggested so-called special masters in the criminal investigation of Donald Trump for illegal possession of government records, including classified records. Donald Trump's lawyers filed their response to the Justice Department's two names proposed as special master. Not surprisingly, the Trump lawyers said they opposed both of the names submitted by the Justice Department. Then the Justice Department replied, saying that one of the two suggested names by the Trump lawyers is acceptable to the Justice Department. That is 78-year-old senior federal judge Raymond Dearie, who was appointed to the federal court in 1986 by Republican President Ronald Reagan at the suggestion of New York's then junior senator, Republican Senator Alphonse D'Amato. Judge Dearie served a 7-year term on the United States Foreign Intelligence Surveillance Court, where he became familiar with the handling of classified material. Earlier today, in the case of Donald J. Trump versus the United States of America, Donald Trump's lawyers filed their reply to the Justice Department's filing on Thursday. The Justice Department demanded then that the Trump-appointed judge in the case, Aileen Mercedes Cannon, reverse herself and exclude the 100 classified documents seized from Donald Trump's residence from any examination by the so-called special master. And the Justice Department demanded that the judge reverse herself on her order barring federal prosecutors and the FBI from continuing their investigation of the classified documents. The Justice Department pointed out that it is impossible for the intelligence community to assess the damages to national security in this case without the FBI's continued investigation of what has been happening with those documents while in Donald Trump's illegal custody. Today, Donald Trump's lawyers said, in effect, that an FBI affidavit submitted by the Justice Department last week by Alan Kohler Jr., the assistant director of the Counterintelligence Division of the FBI, is a lie. Kohler's affidavit said the intelligence community's classification review and national security risk assessment are inextricably linked with the criminal investigation. Donald Trump's lawyers said that is simply not true. The FBI is lying about that. And the Trump lawyers, of course, offered no evidence to support their assertion that the head of counterintelligence at the FBI lied to the judge in this case under oath. We will, in a moment, get Andrew Weissman's expert reading of this pleading along with attorney Mark Zaid's interpretation. But for the moment, I'll point out only one stunningly childish passage. On page 15, the Trump lawyers quote the law accurately, saying, quote, the archivist of the United States shall assume responsibility for the custody, control, and preservation of and access to the presidential records of that president. And then they think they have a winning point in their next line when they say the law, quote, does not say that the archivist must assume custody and control of all materials that fall within the definition of presidential records. So there are the Trump lawyers thinking that they've caught the law writers, thinking that they've found the loophole. The law says shall, it doesn't say must. I'm sorry, but I must now invoke what they call in the Senate a point of personal privilege, and that is, as someone who used to write law, I can tell you that shall means must. Those two words mean exactly the same thing in written law. Laws are not written just by the staff members, like I was, who worked for senators or chairman of committees, where the laws really get written. The committee staff writes the first draft of the law, and then we present it to the Legislative Counsel's office, and that is the place where technical professionals do nothing but write the final words that appear as the law in the United States of America. And they make sure that the legislative intent is clear. They could have written, the archivist of the United States may assume responsibility for presidential records, and that would leave the door open to more than one possibility. And laws sometimes do that. That would possibly leave the door open to the dream world that Donald Trump and his lawyers are playing in, and a Trump-appointed judge in Florida is pretending to believe. But the Legislative Council did not leave that door open in this law. The law says that the archivist of the United States shall assume responsibility. And that does indeed close the door tightly and legally on who has the responsibility. When I read this today, I could not believe that there was a legal practitioner out there anywhere in the United States of America who could read the word shall in law and does not know that it means must. Everyone writing laws intends for the word shall to mean must.